of July 1, 2020, around 1,550 cases have been filed related to climate change in 38 countries around the world. And the key trends in those cases include increasing number of matters related to human rights, challenging domestic enforcement and non-enforcement of climate-related laws, seeking to stop fossil fuel extraction and use, and arguing for corporate liability for climate change. It is very difficult to fix the liability and the right issues and the issues related to climate justice in the climate-related matters. With this background, I can say that the present session will be very helpful to us in understanding the key concerns related to climate change and the climate change regulation. So without taking much of the time, uh, I will just proceed with this session. But before we proceed, a humble request to the participants to keep your cameras on and to keep your microphone on mute mode. And at the end of the session, please send the question answers through chat box to Dr. Bishwa Kalyandas. Now, I would like to invite Professor Dr. Purvi Pokhariyal, Dean and Director, Institute of Law, to deliver a welcome address and to introduce our speaker. Over to you, ma'am.
Thank you, Dr. Madhuri Parikh. Dear friends, we are honored to have amidst us Dean Harry Osofsky, if I pronounced the surname correctly, and pardon me if I'm wrong. We have a distinguished scholar with us. Dean Harry is with the Dean of the Penn State Law and the Penn State School of International Affairs, and a distinguished professor of law, professor of international affairs, and professor of geography. So Dean Harry wears so many hats. As a dean, she is deeply committed to collaboratively building legal and international affairs education for changing society, and is leading initiatives in mentoring, technology, and interdisciplinary and international partnerships. We have just heard Harry's views on how this internationalization is helping to establish a global peace. It's indeed a very novel thought. Dean Harry has been recognized for her technology leadership by the American Bar Association's Legal Technology Resource Center as one of the 2019 Women of Legal Tech. Dean Harry has also been very involved nationally in supporting more women and people of color to consider law school and university leadership. We also have similar kind of an initiatives by one of our great friends, Shamnath Bashir, who has been trying a lot to increase the diversity in the law school. The similar kind of a work that Dean Harry is greatly interested in US. Dean Harry has over 50 publications focusing on improving governance and addressing injustice in energy and climate change regulations. Her scholarship includes books with Cambridge University Press on climate change litigation, textbook on both energy and climate change law, and articles in leading law and geography journals. Dean Harry's Emory's journal article, Energy Partnership, was awarded 2018 Morrison Prize, which recognizes the most impactful sustainability-related legal academic article published in North America during the previous year. Dean Harry has collaborated extensively with business, government, and nonprofit leaders to make bipartisan progress on these issues through her leadership roles and teaching. Dean Harry's professional leadership roles have included, amongst others, serving as the president of the Association for Law, Property, Society, chair of the American Association of Law Schools section on property, and a member of the Executive Council of the American Society of International Law and International Associations Committee on the Legal Principles of Climate Change. She also is a member of the Board of Governors of the Society of American Law Teachers and the editorial board of the Climate Law. Her leadership and mentorship work was recognized by the Association for Law, Property, and Societies 2016 Distinguished Service Award and the University of Minnesota in 2015. Dean Harry received the PhD in geography from University of Oregon and JD from Yale Law School. And prior to joining the Penn State Law, she also served on the faculties of the University of Minnesota, Washington, and Lee University. Dear friends, please join join with me to welcome a distinguished scholar, Dean Harry, with us. We welcome you, Harry, and it's a really our honor to have you with us on this evening. Over to you. Thank you.
Thank you very much, Dean Pokhariyal. I just want to say what an honor it is to be here with all of you, and how grateful I am for your kind invitation to have the opportunity to talk about these important issues together. And I really look forward to the climate change is a problem that we are all working on together, and I look forward to the opportunity to learn from all of you about the innovations going on in India right now around this problem. I want to just make clear that tonight I am speaking in my professor capacity rather than my dean capacity, and represent my individual views as a scholar in making this presentation. And what I'm going to do is share my screen so that to share my slides with all of you. Is everyone seeing them okay? Great.
Yes.
So what I want to talk about today, and my understanding is I'll go for about 30 to 40 minutes, and then we'll be able to have interactive dialogue. I want to sort of first think a little bit about the big picture of climate change governance, because I think that one of the complexities sometimes in how we talk about this problem of climate change is that we don't always fully talk about or acknowledge the many, many dimensions involved in really making progress on climate change. Then I want to talk a little bit about the Paris Agreement, about US multi-level climate change regulation, the role of corporate and financial law and all this, and then I'll focus much of my time, as the introduction said, on looking at the regulatory role of climate change litigation. I was saying before we started that I have never had slides on a topic my information on a topic go more out of date in 2 months than I did today. We've obviously had a major transition of leadership in my country, and that has literally reversed our approach to climate change. And so I'll talk a little bit about that over the course of things. And I now have a picture of President Biden rather than President Trump on my slides as well. The other thing I will note is that one of the things that always goes out of date is my slide detailing the number of climate change litigation cases. Literally, if you go 2 weeks, the numbers change, because this is such a growth area of law, and I think is incredibly important for us to talk about for that reason. So let me talk a little bit about the dimensions of climate change governance. So when I was a junior faculty member and giving one of my first presentations on climate change litigation, I had someone very condescendingly say to me, "Why are you talking about litigation? Don't you know that climate change is about treaties?" I haven't had someone say that to me recently, because I think there's a growing recognition that if we're going to solve this massive global challenge, we have to recognize that while the treaty regime, the international level, is incredibly important to solving this problem, and I'm going to talk a little bit about the ramping up of ambition that needs to happen around Paris as part of that solution. It's incredibly important to recognize that a lot of the decisions that are made that are relevant to whether we're going to control the problem of climate change are not happening at an international level. They're happening at an individual level. They're happening at a local level as we decide sort of building codes. They're happening at state levels, at regional levels, where in the United States, for example, we manage our energy systems at regional levels, and at national levels. And so one of the things, for example, that helped the United States continue to make some progress on Paris obligations, even as the United States was withdrawing from the treaty over the last several years, was the fact that businesses and cities and states were making commitments to maintain what the US Paris pledges had been. And it wasn't enough. The pledges themselves weren't enough. But at least the many levels interacting here make a difference. It's also important to recognize that we're not going to solve climate change, this problem, just through government, because there's a really complex set of interactions going on between government and the corporate and investment sectors and sort of the NGO community that are all a part of solving this problem. And so on the one hand, when we talk about law, we're talking about government, but when we're talking about solving this problem, we have to go beyond that. And so I just want to highlight, as we talk about dimensions of governance, three big problems that plague climate change governance. One is a problem of inadequate authority. So here we have a problem that is truly global in nature, right? It's caused by all sorts of different activities all over the world. Complex scientific process. I actually decided that if in 30 to 40 minutes, I wouldn't have time to do all my science slides, right? But climate change science is complex. And in particular, the climate change science that a lot of us really care about, which is how does this emission right here, right now, cause these impacts right here, right now, is some of the places where there's the most need for additional scientific understanding, right? And so when we try to address this problem of climate change, who has the authority to make the decisions, right? So even at a treaty level, we're depending on voluntary governmental commitments, as I'll talk about in a moment, and no one governmental entity has enough authority to solve the problem. That's worsened by the fact that the relevant law is deeply fragmented, but in overlapping ways. Well, what do I mean by that? For example, in the United States, our key statutes on energy and environmental law are separate. They create separate administrative agencies. But when the Obama administration wanted to sort of lower emissions from cars, it had to bring together environmental law on emissions regulation with energy law and fuel efficiency. And then, as I talked about before, this public-private interface also creates massive governance challenges. So I want to talk a little bit about the overarching international framework on climate change, the Paris Agreement, and sort of the road by which we got there. A lot of international environmental law, in particular, functions on what's known as a framework protocol model, which means that and the basic principle of this, I think, is that we can get a lot of people to agree to not very much, or a few people to agree to specific things, right? In general, in the way humans interact, and it's the same with countries. And so essentially, the United Nations Framework Convention on Climate Change is a very broad agreement with lots of parties, but doesn't do very much, right? It doesn't have a lot of very specific obligations for countries. And so ever since the creation of the Framework Convention, the question has been, how do you create more specific obligations for countries? And so the first approach, and underlying that has been a debate about whether you take a one-track or a two-track approach to doing that, right? So do you want to say there's a certain set of countries who, because of their historical and current emissions, developed country major emitters, who should have obligations that nobody else has and make specific commitments around targets and timetables? Or, do we have some idea that while we have differentiated responsibilities, everybody should be involved? And in some ways, what you see in the Kyoto Protocol is an attempt at that first model. And of course, the challenge of that first model has to do with my country, especially. The United States has a long tradition, unfortunately, of being very, very involved in international negotiations, really having strong opinions in them, influencing the course of things, and then not actually being able to join the agreement. This doesn't just happen in the realm of climate change, it happens all over the place. But with respect to the Kyoto Protocol in particular, the United States was it was a very key negotiator in all of that. And in fact, so much so that its insistence on emissions trading was part of what helped Europe move towards an emissions trading regime. And yet it wasn't ultimately able to ratify and join the Kyoto Protocol, in part because we have a structure by which we ratify international agreements that makes it incredibly hard for us to ever ratify international agreements, right? I mean, and as you said, it's not just climate change. There are human rights agreements that like almost every nation in the world are party to, except for the United States. And so the Kyoto Protocol was able to get enough countries to join it without the United States to move forward, but it was a major problem that such a big emitter wasn't part of it. And as the Kyoto Protocol started to move towards its second phase, there was a continued discussion of a more bottom-up approach in Copenhagen that really led to the Paris Agreement, with this idea that we could build out of voluntary commitments collective international action on climate change if we ramp up ambition over time. And that approach also had the advantage of not needing to be ratified by the United States. So it would allow the United States to join the community of nations. Another piece of what was happening in that same time period was a growing recognition that we used to talk about preventing climate change. And there became a point where it was recognized that we couldn't prevent climate change, and we were trying to mitigate climate change, and an increasing focus on how we have to adapt to this problem that's happening. But what's happened in more recent years is a recognition that some of the harms of climate change are ones we cannot adapt to. That we're beyond even being able to mitigate and adapt in some cases. And in some cases, we have to deal with the loss and damage that results from this problem. So the Paris Agreement entered into force on November 4th, 2016. I have to say that the thing that I was in the room. This is a picture I took when the gavel went down. But what was most inspiring to me as someone from my country, having watched sort of all of the complexities about the US relationship to this, is that watching the United States walk in as a member of the High Ambition Coalition that night to a standing ovation was one of the most moving things about the evening for me, in addition to the agreement itself. Obviously, that didn't stick. We have not really been a member of any kind of high ambition coalition on climate change for the last several years. President Trump, as you know, after he took office, decided to withdraw from the Paris Agreement. That's a process that took several years. So we actually finished withdrawing from the Paris Agreement in November. Around the time we also had an election in the United States that changed that administration. Of course, it was very clear that then President-elect, now President Biden, was going to rejoin the Paris Agreement. He felt so strongly about it. It was in his first group of executive orders he did on Inauguration Day, right? He went from inauguration to rejoining the Paris Agreement. And I have a picture of that in my later slides. Important to recognize under international law that will enter into force for the United States in a week on February 19th. But the key thing about the Paris Agreement more generally is that it has a bottom-up architecture. And by that, I mean that it's all based on what are known as NDCs, nationally determined contributions, and how ambitious they are. And that, in fact, leads into some of the dilemmas right now, because you have to get to the right ambition level. So if you, so I just wanted to talk a little bit about the key goals of the agreement. So one of the big debates in the creation of the Paris Agreement was whether the goal would be 2% or 1.5%. And so what you see in Article 2.1 is a compromise between the two, which is that the formal goal is 2%, but we'll aim better. We're nowhere near 2%. I mean, if we could get to 2%, it would be a big step forward. The other thing is I just wanted to show you very briefly in the slides, as I said, this structure around nationally determined contributions, and this idea that we're going to have each nation voluntarily make these commitments where where ambition ramps up over time. And you can see in these articles the decision in this agreement that of this idea that we're not going to have a two-track approach in the sense that everybody's going to have obligations. But if you look under 4.4, the last bullet there, that we are saying that some countries should have higher obligations than others under this agreement, both because it's needed to solve the problem and out of a sense of fairness. So At this point, we have ratification by 190 of 197 parties, and submission of these nationally determined contributions and long-term strategies and all sorts of pledges by businesses and civil society. And that all sounds very good, except for one big problem, which is it's not anywhere near enough. So if you all have been tracking this issue, you'll know that there was just a study that came out in Nature, I'm sorry, that said that essentially right now we have, they found that there's only a 5% chance of pre-industrial levels being less than 2%, being less than a 2-degree rise. And that in order to really get where we need to go, we would need an 80% ramping up of ambition from where we are right now. Now, that feels a little bit more possible because the United States at least has rejoined the community of nations on this, but it's still, let's not kid ourselves. We are very, very far from where we need to go if we're going to solve this problem. So, I just wanted to briefly kind of take this model I've been talking about and talk about the United States. So that picture, as I said, is of Biden rejoining the Paris Agreement. But what I wanted to represent in this picture is that in the same way that I said, when we talk about this problem, we can't just talk about treaties. If we talk about any given country, and I know that all of you could do this very expertly for your country, you're actually talking about lots of different pieces of the puzzle, right? So it's not just about Biden sitting in that room, rejoining the treaty. It's also about how we're interacting with that moment that I'm depicting of the Paris Agreement with the various kinds of businesses. And businesses, of course, have complicated positionality with respect to climate change. You actually saw a number of fossil fuel companies object when Trump withdrew from the Paris Agreement. And part of what's happened, and you especially have to differentiate between, say, coal and oil and gas companies. Oil and gas companies both have been investing in renewable energy and try to position natural gas as a transitional fuel. And so their positionality vis-a-vis these agreements is quite complex. And then I also have a picture there from years ago, if any of you recognize the governor and movie star Arnold Schwarzenegger from the United States. That picture's there from activities he was taking as the governor of California, to sort of remember that in every country, what we do at a state and a local level is incredibly important in all of this. So in the United States, and this was one of the slides that really needed to be updated in the last 2 months, in the United States, we have not been able to pass any kind of comprehensive climate change legislation. But what we've done is use our existing environmental legislation. We have very strong existing environmental laws. We also have done a lot at the executive level. And what we've seen over the last several years is, of course, the danger of that strategy, which is that it can cause a flip-flopping in regulation, right? Where when the executive changes, you see, so the story of the last 4 years has been Trump rolling back Obama's regulation. The story of the next 4 years will be Biden reinstating and going beyond Obama's regulation, right? So, so it makes it very dependent on who sits in the White House. And then, as I'll talk about later, litigation has played an incredibly important role in the United States and increasingly globally in shaping what is possible, how we fit into that grid of climate change governance I was showing at the beginning. So the other thing that I want to highlight here is that, and this is just giving you a sense of the dynamics in the United States, and I'll be interested to hear some about the dynamics in India. But it's important to recognize that that states really vary in the United States. And as I said, this helped to mitigate the impact of Trump's rollbacks in the sense that a number of states continued to maintain their commitments. But on the other hand, it's important to recognize that when you have a very ambitious federal government, you're going to have state pushback as well. And in cases over the years, and I show here a depiction of, for example, the differences in the percentage of people in my country by state who support participation in the Paris Agreement. And you can see that those percentages are really varying across states. And you particularly tend to see more support in the Northeast and the West of the United States. The other issue, though, and I'll be interested to hear your thinking on whether this poses issues in the United States. As I talked about at the beginning, we have a real fragmentation in the United States between our environmental and our energy systems. And in particular, I depict in that image the map of regional transmission organizations. So one of the things, for example, when the Obama administration was creating the Clean Power Plan, this very ambitious legislation aimed at addressing power plants, a lot of people were focusing on the substance of it. I was worrying about the structure of it, because in the United States, a lot of our environmental law we do in a cooperative federalist approach, where we set federal standards and let states implement. But the problem was that regional energy markets don't fully follow state lines. And so you have to intermesh this regional system, this regional market system, with this state federal system in the United States. And that has a lot of governance complexity that has to be worked through. The other thing to highlight is that, as I said, we can't just talk about treaties and countries. Cities are crucial actors in all of this. A lot of decisions that affect climate change are local land use decisions that are under the authority of cities around the world. And cities are also places where we tend to get practical and cooperative. And because of urbanization going on globally, it's a huge, huge piece of the puzzle. But the difficulty is that it's important to recognize that even if a bunch of cities sign on to things, and in the side meetings around the climate change agreements, you see a lot of meetings of cities and you see these different kinds of coalition of cities, but they don't necessarily represent a high percentage of cities around the world, even though lots of cities are participating. And so one of the things to think about is, how do we deal with this at a local level? It may not always be kind of top-down federal regulation that gets us there. I also want to talk a little bit about how corporate and financial and investment law fit into this picture. So, there's been a lot of attention globally around investment patterns, and a lot of attention given to the divestment movement and various mechanisms trying to change the level of investment in fossil fuel energy and increase investment in clean energy. And so, in particular, so I've been involved in a project now sponsored by the Australian Research Council with Jackie Peel at Melbourne and my colleague Brett McDonald at Minnesota and Anita Forster at Monash, to really think about what are the roles of this. And we both wanted to model. So a lot of the conversation is about, how do you move investment out of fossil fuels? And what we were really interested in also is, but what about reinvestment, right? When you take the money out of fossil fuels, where's it going? Is there a replacement investor so that it didn't actually make an impact? But also, are you investing in clean energy adequately enough? And so, because in our view, the reason this law is so incredibly important around the world to this, and of course, it's multinational corporations that are being regulated by U.S. law and by Indian law and by law all over the world. These investments play a huge difference in whether we maintain or undermine the status quo, and also in terms of whether we spur or limit innovation. And so we've done some studying of the different mechanisms, corporate disclosure of climate change risk, shareholder proposals of fiduciary duties. And we've done sort of extensive interviewing. And what we found is that as of right now, these mechanisms have not yet had massive impact, but we think they have some potential to, and you're already starting to see cultural changes in boardrooms because of them. We also, though, looked at emerging law that can help spur the reinvestment piece of it. How do you get investment into clean energy? How do you get companies across that valley of death to being able to be productive? And so we looked at a variety of changes in U.S. law, from making it easier to invest in projects to new structures for corporations that can help incentivize that. But where I want to end and spend the rest of my time, because it looks like I probably have about 10 more minutes or so before I should open it up. is I want to focus in a little bit on litigation as a regulatory tool. And I want to make clear that in talking about this, I'm talking about strategic litigation. So some of litigation is just you're representing a client and helping a client to get their interests advanced. But in strategic litigation, you're also trying to advance policy goals through the litigation that you're doing. One of the things that becomes very complicated in the context of strategic climate change litigation is defining what it is, because there's a core of cases that are clearly about climate change. And then there's a set of cases that mention climate change, what we're calling peripheral cases. But there's a whole lot of cases that are motivated by climate change or have consequences connected to climate change that aren't even talking about climate change at all, because we live in a carbon economy. For the purposes of my presentation today, I'm going to focus on that red circle, the core cases, and talk to you a little bit about how that has evolved as a regulatory force around climate change. So this is a slide I updated last night. It may be out of date already. That's how fast this moves. There's now been climate change litigation in 29 countries around the world, plus the European Union and other regional and international tribunal across 6 continents. If we were in interactive mode, I'd make you guess what continent is missing, but I'll tell you it's Antarctica. You can see that the vast majority of this litigation has occurred in my country. At this point, over 1,300 cases have been filed in the United States. And just to put that in perspective, when I first started looking at the regulatory role in climate change litigation, when that person said to me, don't you know it's all about treaties? That was in the mid 2000s. So only about a decade and a half ago. We'd only had a handful of cases in the United States. It was before Massachusetts VPA had made it to the Supreme Court. In the last decade and a half, we've gone from a handful of cases to over 1,300. It's an enormous growth in litigation. That number of 447 filed around the world is from the Columbia University Climate Change Database, but I should note that there's other people who are compiling these, such as LSE and Melbourne, who think the number is higher than this, because we think that in the international survey, there are cases missing because of translation. There's probably a lot more than 447. The key thing to recognize is that even though we hear a lot of attention, and I'm happy to talk about those cases around some of these very high profile human rights cases in the climate change space like Urgenda, it's important to recognize that most of the litigation, or for example, in the United States, the Juliana case got a lot of attention. It's important to recognize that the vast majority of cases around the world have always involved statutory pathways. So it's interpreting statutes in various ways, applying statutes, and in particular, a lot of the cases around the world have been around how do you deal with the environmental impact of climate change when you're approving new projects. While there have been all of these interesting trends and new kinds of cases about adaptation and about human rights, it's important to recognize that primary statutory focus. The other thing is that it's important to also recognize when we talk about litigation that it's fundamentally a neutral tool. So you tend to see in response to a lot of regulatory activity, anti-regulatory cases. And so I fully expect to see a lot of, for example, the Biden administration's activities challenged in court. I even had a colleague back when Obama was president say to me, do you think overall the litigation is going to end up being more anti-regulatory than pro-regulatory, right? Well, it depends who's the leader is. So it turns out under Trump, we had a lot of pro-regulatory litigation. So it really depends. But what Jackie and I have done is create this map for thinking about the impact of this litigation. And the key thing to take away from this is that there are a lot of direct effects of litigation that you can trace. But in many ways, the indirect effects are often just as important. The way it changes corporate and individual and governmental behavior beyond what the case formally requires. So in the United States, the most famous case, and the one that's probably, some people have called the most important environmental case of all time in the United States, is the Supreme Court in Massachusetts v. EPA, in which our Supreme Court found that essentially the Bush administration either had to regulate more or justify why it wasn't regulating under the Clean Air Act. And that became, and this was about motor vehicle emissions, that became the legal basis for a lot of the Obama administration's regulation of motor vehicles, of power plants, et cetera. But it's important to recognize that though that case is very famous, and though climate change has been to the Supreme Court 3 times, the vast majority of cases in the United States have been about coal-fired power plants, and in particular about sort of that environmental review process around them. And the other thing that I want to highlight here is just that something to think about that I think might have some relevance for India. There's this case in the United States that nobody knows about. So I've been telling you about all these famous cases, but called Borough of Harvey Cedars versus Karen. And what made this case so interesting, and it's a state court case in New Jersey. It's not something that's had big national impact. It's the reasoning I find interesting. So this was a community that wanted to build protective sand dunes to deal with the coastal impacts of climate change. This is obviously a huge problem in India, the coastal impacts of climate change. And we, under the Constitution, have this doctrine under takings, known as takings, where you can take someone's property for public purpose as long as you give them compensation. And everyone agreed this was a taking and it had a public purpose. The question was how much compensation? And originally the lower court found about $300,000. And the New Jersey Supreme Court reverses and says $1. Because you have to take into account the protective impacts of these mitigation measures when you think about what compensation is owed. And so I think around the world, as we move into loss and damage mode, we're going to think about these kinds of questions about how much compensation is due around the harms of climate change. And so I find this case a really interesting example for thinking about it. Australia is the second biggest jurisdiction in the world for climate change litigation. And it, like the United States, the vast majority of cases have been about coal-fired power plants. However, Australia is the developed country in the world that has had the fastest frontline impacts of climate change. And so it's also had a really interesting emerging adaptation jurisprudence. Actually, Jackie Peel and I several years ago went to look at what the United States could learn from Australia and basically predicted wrongly that we'd see more of an expansion of these adaptation cases in the United States, which we really haven't seen as much of. But there's an interesting model for around the world in Australia from these cases. Climate change litigation has only begun to emerge over the last several years in Europe, in part because Europe doesn't have as strong of this type of litigation tradition as other countries. And a lot of the countries in Europe are civil law countries as well, where litigation works quite differently. I've, in the interest of full disclosure, been involved for several years now as a consultant to the Children's Investment Fund Foundation, together with Jackie Peel, in which we've been evaluating the investment that they made in Client Earth of several $1 million to seed climate change litigation in Europe. And so that kind of foundation investment has actually played a really important role in helping to expand that litigation in Europe. But what I highlight here is one of the most famous cases in the world, and certainly the most famous case in Europe, which is the Urgenda case. I don't necessarily think it's a model for very many jurisdictions. It is being replicated in some European jurisdictions because it's very specific to the legal system of the Netherlands. But it's a really important example of the highest court of a country finding that country is not doing enough to protect against climate change and requiring it to do more. Closer to India, there's a really interesting Pakistani case that deals with where the court found a breach of citizens' fundamental constitutional rights due to adaptation failures, right? And a failure to adequately implement the National Adaptation Plan that I think provides some interesting models. As I mentioned, these environmental assessment cases are happening all over the world. And so I just wanted to highlight an example in South Africa, another one of these environmental assessment cases about prospective coal plants. And then I also wanted to highlight an interesting human rights case going on in the Philippines. that essentially is against companies claiming human rights violations. Last but not least, I just wanted to briefly highlight China. It's something that people haven't been talking about a lot, and I think is super interesting. So China is obviously the biggest emitter in the world. It has lower per capita emissions than the United States, right? So I'm not trying to make any claims about the relative obligations of my country. But obviously solving the problem of climate change, China is a big piece of it, just as India is a big piece of it, just the United States is a big piece of it. And so what's interesting in China, of course, is it's a very different form of government than our democracies, and a different litigation tradition. You know, I actually spent a year in China teaching US civil rights law and helping to start a labor law clinic a couple of decades ago. And you know, and that was the first year that they even had a unified bar exam, right? Because after the Cultural Revolution, there was a restarting of the legal system. But what's so interesting in China is that because of their form of government, when China makes commitments in its nationally determined contributions, those commitments then got brought into the 5-year plan in China. And they've actually had their Supreme People's Court, and I presented to them a couple times, talking about where climate change litigation might appropriately evolve in China. And there's actually the first case that's been making its way through the courts, Friends of Nature versus Gansu Power Grid Company, which is dealing with the ability of renewable energy to connect to the grid. And so I raised this China example to just say that when we think about litigation, it's easy to focus on my country because that's where the vast majority of this litigation has taken place. We're very litigious in my country. But obviously there's a really strong public interest litigation tradition in India as well. And some of the most cutting edge environmental rights litigation in the world occurs in your country. But it's important to look at different models and to recognize that even in countries with very different legal systems, litigation has the potential to play an important regulatory role. So when we think about the big picture of how strategic litigation is impacting this problem of climate change, you know, there are a few things I think that we can reflect upon. I mean, one is one I've said over and over again, which is that most of these cases remain statutory, even though there are a lot of different approaches. The second thing is that I think a lot of times we focus our public energy on those high profile cases, but it's important to recognize the cumulative transformative impact of some of the smaller cases. When we think about these cases, it's important to think about their indirect, not just their direct effects. So a great example of this is I assisted on the Inuits petition to the Inter-American Commission, claiming that US climate change policy violated their rights. That case had very little chance of formal success, and it didn't have formal success, but it played an important role in raising the profile of the problem, and had some indirect effects. Litigation is most effective as a regulatory tool when it's part of a broader campaign. So for example, in the United States, these coal cases were also interconnected to a broader advocacy campaign by the Sierra Club. But it's also, again, as I talked about, important to recognize litigation as a fundamentally neutral tool. So you can get backlash. So just because you win in court doesn't mean actually you get forward movement in policy. And that you tend to see these patterns of pro and anti-regulatory cases, depending on how pro or anti-regulatory the underlying government is. So in the final analysis, I wanted to share with you just a couple of quotes that came out of Jackie's and my interviews, because I think as we think together about how to solve this problem, they sort of highlight this, which is that litigation and all of these different things, corporate and financial investment, local government action, national action under the Paris Agreement, all of these things are important tools and important pieces of the puzzle to try to solve this problem of climate change. But fundamentally, there's not one magic answer to it, right? There's not this one thing we can do and solve this problem, because it is so global, but also not just global, but so multi-level and so multi-actor as a problem, that what we have to do together is to use every kind of tool in our arsenal to try to make progress. And so in my view, litigation is one of the important tools of helping to shape the direction of government policy in this area, but it also is not a panacea. And to really make progress on this one of the largest problems facing humanity, even amid a global pandemic, which is obviously a huge problem facing humanity. We need to think about how we creatively work together to use these different kinds of tools. So with that, I will stop and open it up to broader conversation. I think that was about 40 minutes.
Thank you so much, ma'am. And we got many insights into this discussion on the climate change regulation, and we do face, like we are able to relate, because in India also we are facing certain problem related to environment impact assessment and the environment clearance and the forest clearance issues, which are directly indirectly related to climate change. So thank you so much for this talk. And now I will invite the question answers, and I request Vishwa to take the questions.
Okay, thank you, ma'am. And first of all, thank you, Dean Harry, for such a wonderful lecture, because these are too much of information to grasp at one go. And climate change itself is such a heavy word and a heavy burden on all of us that we have to carry this burden all together. But before I move on with the questions, we have so many questions, but can I please request all the participants to please switch on their cameras, because it cannot be a better option for us to click a picture together virtually than being together. So please, if I may request all of you to switch on your cameras and bring on your smiling faces. Oh, we are getting joined by so many people. Great.
By the way, can I just say, while we're waiting for people to turn on their cameras, how impressed I am. It's Friday night for you guys. And it's so amazing to see so many people joining us in dialogue about this important issue on a Friday night. So thank you for being here.
Great. Now I should turn into the question, Dean Harry. We have a lot of questions, but I would definitely take them one after the other. We have a question from one of our student, Abhishek Bhati. He's asking that, what is your view on the practicability of the Green New Deal sponsored by the representative Alexandria Cottage, and whether it is going to the future climate governance in the US? What is your take on it?
That's a great question, and obviously one that has a lot of debate in my country. I actually tend to, so I certainly think that there are aspects of what they're trying to achieve in the Green New Deal that are really valuable. But I actually am pretty supportive. And again, this is more political than I typically am as a dean. So it definitely is my individual views. I'm actually supportive of the approach that the Biden administration's taking. I think that it brings in some of the elements of the Green New Deal and in really positive ways. But I don't think all aspects of the Green New Deal are sort of the right pathway. And I think that this sort of the sort of more middle ground approach that the Biden administration is taking makes sense to me. And one of the things I want to particularly highlight that impresses me about what the Biden administration's doing is it's brought environmental justice and energy justice to the center of this conversation. One of the things I'm very, very worried about, and that I think is a nuanced problem in the United States, is I've been worrying for some time about making sure that we don't go about our clean energy transition in a way that actually exacerbates energy inequality. It's incredibly important that we not do that in the United States or globally. And so one of the And so, even in the United States, we have a huge energy poverty problem. We have a problem with people who can't get energy, and people who are paying rates, and we talk about these new clean energy jobs, but the very poorest people in our country don't always have the ability to get those jobs. And part of the problem of that is, there's the classic environmental justice questions, right, of the unequal distribution of pollution burden, and that's often intersecting with the energy industry. But there's also these problems of how you how you make sure that as we do these things, that these opportunities are open to lots of people. So I'll just give you a very quick example of why I think this is so important. When I worked in Minnesota, in North Minneapolis, there's which is a predominantly African-American community that has high unemployment rates. People aren't getting the new solar jobs that are growing in Minnesota because the closest place to have job training for solar jobs is an hour away. By bus if you don't have a car. And so I just think that it's important for us to think creatively. And I was really excited to see Joe Biden nominate my friend Shalonda Baker in this energy justice role. She's done really important cutting edge work, and I think that'll be important. So in answer to your question, no, I don't fully support the Green New Deal. I support aspects of the Green New Deal. And I really feel very positively about everything I've been seeing in the direction that the Biden administration has been taking so far. Obviously, it's early days.
Good. We have to cover a lot distance to know about it. We do have follow-up questions by one of our students, Anshika Pandey, and I will be taking two questions together. Anshika Pandey and one of our faculties, Amit Kashyap, sir is asking that given the importance of approaching climate regulation from a more interdisciplinary perspective, do you believe the concept of carbon markets can prove as an effective means of climate change mitigation while recognizing the politico-economic differences in the international community? How do you answer?
That's a great question. All right, you said use the second one though.
Yeah, it's in the same line of carbon markets. How do you see that?
Okay, great. Happy to talk about carbon markets. Carbon markets are only as good as the way that they're structured. So the answer is that I think market-based tools can be an important policy mechanism for solving the problem of climate change, but it all depends on how you structure it. So we saw this, for example, in the European emissions trading system. It depends like how if you don't set it up in an ambitious enough way, it'll have very little impact. And so it's really about how you do the allocations in the market and how you allow the trading to happen that will determine whether the market-based mechanism is an effective tool. In my view, the key here, like there's a lot of debate often about market mechanisms versus tax mechanisms in the climate change regulation space. And I in general think more important than which mechanism, because I think they can both achieve those goals, is what are the details of how you structure the mechanism.
Great. We don't want any of the questions to get unanswered because there are a lot of questions and they're really interesting ones. Ma'am, may we take a few of them? Great.
And I'll try to be short in my answers.
Precisely. So there is a question by Nandini Goel, one of our students, who is asking, we have a number of international environmental treaties and agreements. However, the biggest obstacle to global action remains the implementation gap. So how international governance can bridge this gap? And how do we solve these issues of implementation?
Well, luckily, this is a very small question with a quick answer. I'm joking. Yeah, so huge question, really important. This is exactly what I was just talking about with the Paris Agreement, where we have to ramp up ambition by 80% if we're really going to even get to the 2-degree goal, right? This is a huge problem across environmental agreements. And I think what we've seen, so if you take the Montreal Protocol as an example of perhaps one of the most successful international environmental agreements, part of its success was that it aligned really well with kind of what companies could do and market incentives. So the companies had an alternative and were able to and so it was able to move quickly. And so what I would say is that part of how we bridge this gap is we recognize that fundamentally there's a voluntariness around our international governance system that's problematic. And so we really have to build effective multi-stakeholder coalitions that include corporations, that include all different levels of government, NGOs, governments together in order to solve these kinds of problems and to start to bridge these gaps, because it's a huge issue. You're absolutely right.
Great. Now, it's always overwhelming for me to see my student, who is now a faculty at one of the law schools. She's asking Miss Nikita Patajoshi that how to deal with the separation of powers narrative and arguments in climate change litigation when the judiciary primarily shies away from deciding cases, stating that climate change is actually an executive's prerogative. And how do you see this conflict between executive and judiciary with respect to climate change?
Yeah, it's a great question. And I think it comes up in two different ways. So one of the ways you saw that is in a couple of the Supreme Court cases in the United States, for example, where in AEP versus Connecticut in particular, the Supreme Court basically found that while public nuisance could be a pathway here, that it wasn't going to allow this parallel pathway because of the legislative pathway offered under the Clean Air Act. So I think that, you know, what you do see is courts kind of working through these issues around authority. I mean, it comes up in the Dormant Commerce Clause cases too, like when are states exceeding their authority? How do you balance federal and state authority? I think there's another question though that isn't exactly federal state authority, but is about the role of courts, and that is how the courts feel about talking about climate change science. And in particular, you know, I've written about, for example, Scalia's famous quote where he's like, troposphere, stratosphere, I'm not a scientist, I shouldn't be talking about this. And I think we have a fundamental problem, not just in the climate change space, but it's why I'm so committed to interdisciplinary education. It's why I'm so grateful. I actually was asking Dean Barnes last night, and I'm glad I took them out because I wouldn't have made it in 40 minutes, but whether to put in my climate science slides, because you know, for me, having taken climate change science from someone who contributed to the IPCC report was so important to my understanding of the law. But so many people who do climate change law don't understand climate change science. And so many of the scientists don't understand the laws. And you see this, you know, really both from making regulation and courts dealing with it, a real struggle around kind of fast moving science and technology like this technology. And so I think it's not simply that structural governance problem, but this foundational problem of how we create interdisciplinary understanding in the way we create law and policy.
Great. It's again an overwhelming statement when your director, Professor Purvi Pokhariyal, leads you with from the front with a question. So this question is from Dr. Purvi Pokhariyal. She's saying that Dean Harry, where you are talking about cumulative impact of lower profile litigation, it's certainly true. But would you agree to the point that to happen, awareness and desire to act amongst the common masses about the problem of climate change is the first step? And what would be your take on that very first step is missing, and how do you deal with that?
Can you say that one more time?
So she's asking that.
I just want to make sure I get what the first step is.
The first step is like cumulative impact of lower profile litigation and sensitizing the masses about the climate change factors.
Yeah. I think it's an incredibly important question because fundamentally, we're not going to get to 80% without a culture change. And you know, it's not just about a legal change. And that's part of why we were so interested in sort of interviewing corporate executives about how, for example, they see these shareholder suits or the disclosure agreements, because you know, that goes to this question of are people going to be behaving differently as they make their investment decisions in their corporate boardroom. So I do think this question of cumulative impact, you're right, is sort of really important. But I think that the problem is that our cumulative impact right now just simply isn't enough, right, as a baseline. And so And so how we both can celebrate that there have been some progress, but recognize it's just not even in the neighborhood of where we need it to be. And so, how we then really start to create that culture change, I think, is incredibly important. Did that get at your question well enough?
Great. So there are two questions, one from our PhD scholar, Arjit Pandey, and one of our faculty is Dr. Binny. They're asking a common question that the people's movement in the global south have played a vital role in challenging the nexus of corporations and government so that the mindless destructions in the name of development is resisted. Such movements have led to radical revision of environmental policies. Do you see a disturbing dearth of such movements in the global north?
That's a really good question. So, I began working on all of these issues when I was a law student because I helped on the Shell Nigeria case, where the lawyer and poet Ken Saro-Wiwa was executed by the Nigerian government together with other environmental activists for sort of opposing kind of this rampant environmental destruction in these indigenous communities. And so I think this question of kind of power and kind of the ways in which you sometimes see destructive behavior from corporations in so many contexts is problematic. The question is, how do you fix it? And one of the things I've worried about, and this is something I worry about with the divestment movement more generally, is if you get a multinational corporation to pull out of something, the question is it not going to happen, or is something going to replace them? And a lot of times what you see is a corporation with less accountability than the multinational who's pulled out coming back in to do the project. And so I think that I guess that's part of why when I tend to think about solutions, I think we have to have a lot of solutions in our toolkit. And I think sort of an effective movement has lots of pieces to it. But I do think an incredibly important piece is some of this collaborative work going on with corporations, trying to help them shift their practices, their investment practices, and the way they do business. And I've been really heartened in some of the conversations I've had with energy executives more recently, who recognize they need renewable energy in their portfolio. Like that, even that recognition is an important step forward. So I share your concern about that behavior. And I think the question is, how do you use a series of tools to start to move the needle on it?
Thank you so much. And we have one question from Dr. Madhuri Parikh herself. She's asking, what is your take on the role of non-state actors in the implementation of climate change regulations at the international level?
So there are lots of different types of non-state actors, of course. And in some ways, I mean, so you have NGOs and you have international organizations. And what's been interesting to see, but you also, I mean, in some ways, local and state governments, like subnational governments, even though they're not international organizations, are sort of playing that role because they create these international organizations among themselves, and they don't have the legal authority to be in the negotiations themselves. So, and then you have the corporate actors who aren't what you typically might be referring to in a non-governmental organization context, but who are non-governmental entities that play this huge role in all of this. And so I guess what I would say is, you have you have a lot of non-governmental actors playing an important role in the formal climate change negotiation. So you often see them involved in the delegation positions of different countries in various ways, pretty directly. And there have been new mechanisms for them being involved. But you also, with all these international negotiations, have these various side meetings, and the side meetings end up being really important as well, and often are creating parallel action.
Great. So that brings to the end of the questions, but one last question from my end. Dean Harry, how do you see climate change, sovereignty, and statehood when all three are interconnected? What would be your concluding remarks for protecting the climate by means of the rest two as players?
What a wonderful question. So climate change, sovereignty, and statehood, all big topics, right? Um, so so in some ways, I think we need to start with the sovereignty and statehood and make our way back to climate change. So fundamentally, if we go back to that first slide that I was sharing, and let me see if I can share it again, because I think it goes to this question, except that it's, of course, telling me to exit my slideshow, which is not very helpful. Okay, so let me just see. Here we go. I find Zoom PowerPoint. Okay, so this is the slide I wanted us to look at when we talk about this issue, because so fundamentally, all of our international agreements and systems are based in a Westphalian idea of sovereignty, right? That centuries ago we decided that the way we make international law is through agreement among sovereign but equal nations. Now, that's really what underlies all of what we're doing still in international treaty making. But I think that one of the fundamental problems we have to deal with is how power intersects with all of that, right? So even if legally we maintain this idea of sovereign and equal nations, and that's how agreements are structured, we also know that there's unequal power underlying them, and much inequality in the world. One of the fundamental unfairnesses in this problem of climate change is that the countries that have been the biggest contributors to climate change are not the countries that are facing the most immediate and biggest harms from climate change, right? That's a foundational inequality built into this system. And so, and you see in the actual making of international law, I've had friends, for example, who have served on the delegations of small island states in climate change negotiations. And you think about in the negotiation itself, the inequality so the United States brings this huge delegation of people, and they're just constantly refreshing who's negotiating for them. And for some small and poor nations, they may not even be able to send someone. They may just have like an NGO helping them out and no ability to refresh. And so even in that moment in which we're making these agreements, we see these fundamental inequalities playing out. So I think that one of the things we have to do is say it's incredibly important for us to have this international agreement, right? I mean, on the one hand, we want to celebrate that we were able to get to the Paris Agreement. The Paris Agreement is, this incredibly significant step forward in our international efforts to do climate change, and it was supported broadly by nations of the world in a really important way, and that is great, and it represents their expression of sovereignty and their expression of statehood, and they as states making commitments around this problem. But we have to recognize that even in those Paris negotiations, those inequalities were playing out, and in the implementation of Paris, unless we can get the ambition levels up, and even if we got the ambition levels up, right, we know that massively terrible things will happen to lots of people around the world, even if we can hold to 2%, right? So I think that fundamentally, as we think about this problem of climate change, in some ways it highlights the dilemmas that I was trying to portray in this slide of that while we do have this formal structure that's incredibly important, grounded in sovereignty and statehood, we have to understand the many dynamics that are taking place and the many key actors that are relevant outside of these formal negotiations, and that any solution to climate change has to both embrace the progress that we were able to make formally and recognize that these other pieces are incredibly important too.
Thank you so much, Dean Harry. Now, before we move on with the official vote of thanks, I would request Dr. Purvi Pokhariyal to please give her concluding remarks.
Thank you, Dean Harry. It was indeed a very enlightening sessions. In a short time, in 40 minutes, you covered all the aspects, making it the comparative analysis. It was a indeed very brilliant talk. Thank you so much. And as I said earlier, we look forward to your visit again in future physically on the campus. Thank you.
Thank you, ma'am. And now I would request Nandini Goel, our student, to propose the vote of thanks.
Good evening, everyone. I, Nandini Goyal, on behalf of Institute of Law, Nirma University, would like to extend heartfelt thanks to our esteemed guest, Dean Hari Osofsky, for accepting our invitation and providing us with her findings, and also provided us with the insights of how US has tried to fulfill its obligations and where the gap still remains, and also provided us with the comparative view of how various countries are using litigation as a tool, a regulatory tool. Further, I would also like to thank respected Professor Stephen Barnes and our beloved Director and Dean, Dr. Purvi Pokhariyal ma'am, for continuous support and guidance and for providing us with this opportunity. I would further like to extend gratitude to Dr. Madhuri Parikh ma'am and Dr. Bishwa Kalyan Das sir for moderating this session and ensuring its smooth conduct. I would also like to thank Professor Shreya Srivastav ma'am for coordinating and putting in her all efforts for the International Teaching Month. This session wouldn't have been possible without the team effort put in by all the faculties, the technical administration team, and NILSA and all the other committees. So I extend heartfelt thanks to all of you. And last but not least, a sincere thanks to all the audience for being patient with us and for joining us. I would like to again thanks everyone. Good evening. Have a great day and weekend ahead.
Thank you, Nandini. Thank you, everyone.
Thank
you.
you. Thank you, everyone.
Thank you.
Thank you. It has been such an honor. I really
Thank you.
appreciate your including me here and look forward to our continued development of partnership and to the day when we can all visit each other's country again. Thank you so much. It's been what wonderful questions and what a wonderful opportunity to dialogue.
Thank you so much.
Thank you so
Thank you.
much.